Welcome to the Robinson Lloyd Career Training Institute's Continuing Education Course Number 1, Agency Law. My name is Attorney Robert Flesses, and I'll be your instructor for this course and all of the required and elective video home study courses offered by Robinson Lloyd. This is how I'm presenting the agency course. I divided this course into 4 short videos. The video that you're watching right now is the first of 4 on the topic of agency law. Watching all 4 videos earns you credit for the agency course requirement by the state. I'm doing it this way so you don't have to sit through one long course video all at once to earn your credit. The 4 agency videos are broken down as follows. The first video is a general discussion of an agency relationship. The second video will discuss your duties to all parties to a transaction. The third video discusses the creation and termination of agency. And finally, the fourth video will be the review for the test. Let's get started. Why are we interested in agency? You're confronted with agency law every day in your real estate career. Understanding agency relationships is critical. You have both legal and ethical issues that you'll be confronted with when dealing with the public in your real estate transactions. Relationships are created in a number of different situations. You create agency with a buyer or seller and a landlord or a tenant. Who you represent and the duties you owe is the whole point of agency. You're representing the interest of a client. Agency law was created to protect the public, and you're required to understand how agency operates. Take the example of a divorce in a legal setting. It's unethical for an attorney to represent both spouses. Now, why is that? It's because both parties have competing interests. How could one attorney give advice to both of the parties when competing interests exist? They can't. The divorcing parties are dividing up assets, possibly dealing with custody and placement issues if they have minor children, and other considerations. The same thing applies to you as a real estate agent. You can't represent the interests of both a seller and a buyer simultaneously, or a landlord and a tenant for that matter. They too have competing interests. Well, here's a simple comparison. Let's analogize agency law to a football game. If all of the players on the field during a game wore the exact same uniform, you wouldn't know who's playing for which team, right? As a fan, you'd be confused. And I bet the players would be confused too. That's why we have agency rules in real estate. A lister is wearing one uniform and the buyer's agent is wearing a different uniform. Everyone in the game, or for our purposes, the transaction knows which team each agent is playing for. No more confusion. The point is that we're avoiding conflicts of interest, and by operational law, abiding by the state rules that set forth your duties to the parties. You'll see evidence of this when I discuss some case studies from actual real estate examining board investigations that resulted in sanctions against licensees for not following the agency rules because the licensee either didn't know the rules or intentionally failed to follow the rules. If I asked you this question, what is agency law? How would you answer it? Well, could you answer it? Agency law governs the relationship between an agent, a client, a principal broker, a sub-agent, and a customer. It ensures that the interests of all parties involved in a transaction are protected and provides guidelines for ethical conduct and fiduciary duties required of the agent. Your agency defines your distinct role and responsibilities in order to protect the public. Agency, in a real estate context, is a relationship that's created by a written contract executed by 2 or more parties. Each party to that agency agreement has a role. One party is the client or the principal, and the other party is the agent of the principal. Licensees must disclose their agency relationship to all parties involved in a transaction and obtain their client's written informed consent to act as their agent. In real estate, there are basically three types of ways that agency is created. The most common agency that you create is with a seller under a listing contract, or with a buyer under a buyer agency contract. The second agency is created with a real estate management company and a landlord to manage residential or commercial real estate. The third agency is created with a prospective tenant to find either residential or commercial property for their client to lease. In order to create agency, you need to use the required forms that indicate the agency and provide notice to all of the parties that are involved in each transaction. What types of contracts create agencies? The most common type of agency contract is, of course, a listing contract. Another type of contract that creates an agency is a buyer agency contract. The third type of contract that creates an agency is a tenant representation agreement. And the fourth type of contract that creates agency is a property management agreement between a property manager and a landlord. If you work with a seller, that seller is your client. If a customer eventually signs an agency agreement with you, then they're elevated to a client and now they're the principal. Here are the general rules that you must follow when you're involved in an agency relationship. Firms and licensees can provide brokerage services to any party, whether it be a client or a customer. It doesn't matter. But here's where it gets sticky. You can't represent both the buyer and seller as clients in the same transaction. And based upon what I said earlier in this video, they have competing interests. The seller wants the highest price they can get. Conversely, the buyer wants to pay the lowest price. There's no way you can deal with that. To negotiate on behalf of a party to a transaction, that party must either be a client of the firm or be a client of the subagent's firm. The agency agreement must be in writing, just like any other contract. Licensees have to explain to their clients the responsibilities and roles of listing agents, buyer agents, and subagents before entering into an agency agreement. As the lister, you can't permit other firms to act as subagents in a transaction unless the seller has authorized the use of a subagent in the agency agreement. Now let me explain that. You listed a property with a seller, right? Next, you want to enter the property on MLS, which is allowing other agents to participate in the sale. You also have to upload portions of your listing contract to MLS showing that, number one, you're authorized to list the property. And number two, you have the seller's consent to offer compensation to MLS member agents. So two important things happen in a listing contract. First, you've created an agency relationship with a seller. The seller is now your client. Second, the seller has authorized subagents to participate in the sale of their property and receive compensation upon the successful closing of the property. Well, what happens when a subagent shows your listing and submits an offer? Let's say a buyer agent shows your listing and submits an offer. The first thing you look at is which team is the agent playing for, the seller's team or the buyer's team? The Green Bay Packers or the Chicago Bears? Which uniforms are the participating agents going to wear? At lines 1 and 2 of the offer to purchase, it's designed to clearly indicate the relationship of the agent to the transaction. Either the subagent is working as a buyer agent or the subagent is working as what? An agent of the seller. There's a third option in lines 1 and 2 of the offer to purchase. The agent can be working as an agent of both the buyer and the seller. Now wait a minute. How can you work as both an agent of the seller and the buyer? Is that even possible? This is how that type of designation would work. Your firm has both the listing contract and a buyer agency agreement. The buyer is your client, and that buyer wants to put in an offer on your firm's listing. This results in a multiple representation relationship, which we'll get into deeper later in this course. To represent both the buyer and seller according to the offer to purchase, either you're the only agent in the transaction or one of the parties to the transaction agreed to multiple representation but won't agree to designated agency. So you're prohibited from placing the interest of either the buyer or the seller ahead of the other. You must be neutral. If you are neutral, one agent of the firm can draft the offer and facilitate the entire transaction if one of the parties declined designated agency. Both are clients of the firm. Remember that. In the scenario that I just described, what would be the very first thing that you do before writing the offer? You'd look at the agency agreements that are on file with your firm for each party to the transaction. If you did under this scenario, you'd find that the seller's agency agreement allows multiple representation relationships with designated agency. When you look at the buyer's agency agreement, you'd find that the buyer's agreement allows multiple representation relationship but doesn't allow designated agency. And it could also be the reverse of that. So both clients allow multiple representation relationships, but the buyer refuses to allow designated agency. If they both allow designated agency, then the firm would designate one agent that would represent the interest of the seller and one agent within the firm that would represent the buyer's interest. We're going to discuss multiple representation relationships and designated agency in detail later in this course. But for now, we're talking about lines 1 and 2 of the offer to purchase when an agent's agency disclosure states that the agent is the agent of both the seller and the buyer. Since one of the parties doesn't agree to designated agency, then the agent can only facilitate the transaction and must remain neutral. The facilitating agent can't represent the interests of either party to the transaction. In this situation, the agent would indicate in the offer that they are the agent of both buyer and seller. See how this can get really messy? There are many agents out there in real estate land that fail to make the agency determination before proceeding with the transaction. You'll also be confronted with agency issues when dealing with a FSBO. Let's say you represent a buyer who wants to put in an offer on the FSBO's beautiful home. How do you deal with this scenario? Well, let's look at that. You go back to the analysis I just gave you. Who are you representing here? If you have a buyer agency contract, you're required to be loyal to the buyer. That's your client. The seller could think that you're representing them, and you're not. But that's possible. Smart sellers hire an attorney to represent them. Problem solved. I could get deeper into an unrepresented FSBO, but I've run out of time. You've got the basics of agency down now, at least I hope so. And this completes part 1 of 4 of agency. I'll see you in part 2.